My military career spanned 31 years, and it spanned from progressive, bottom line, accountable positions, starting off as platoon leader, all the way up past division commander to ultimately retired as the commander of Texas Army National Guard. In each one of those positions, there was an accountability, there was an answerability, and not only to the people that I was given charge of, but also to my seniors, as well as the citizens of this great country. And I performed those duties in an admirable manner. There was never any question about who I was, where I came from, in my background. We in the military, senior leaders, are never afforded the opportunity of subjects like plausible deniability, but rather, as a leader, we're held accountable to the reaction that we're in a leadership position and we're answerable for everything that happens or does not happen under your watch. The topic of plausible deniability does not fit into the military jargon. My military career ended in March of 2009, retired back here in my home area with an honorable discharge. What I'm talking about today, and the reason why this case is with the Adjutant General's Department, and clarify the difference between the Attorney General, who is the law enforcement, or the attorney for the Adjutant General's Department. My lawsuit is against the Adjutant General's Department, who is part of the executive branch of Governor Perry's administration. Not only am I going to accomplish and be victorious in the end about clearing up this issue, but also illustrate the aspect of this being just another political smear by politicians against the military and the veterans. And those of you folks know that as much as I've worked with the veterans here in this area, is that I've prevented that from happening. I've stood there and been a voice for them, whether it be against the Veterans Administration, the government at hand, because I believe that the character of a nation is determined on how it treats its veterans and how it treats its elderly. And right now, we're not doing real good on either areas, because as most recently seen in the federal shutdown of the government, the first two groups they went after was the veteran and they went after the elderly. And I've stood here in East Texas working on issues because we have veterans in East Texas, even though that I was told to my face, there are no veterans in East Texas. There's 18,000 veterans in Smith County alone, and with their families represent about a 20% population footprint in a $180 million interject into the economy on an annual basis, and those are low numbers. That's not economic impact, that's economic interjection. Those are real live dollars. So I'm going to continue to press on with this case and make sure that similar issues do not ever happen to my brothers and sisters, veterans, and people in the active component today. As a result, what we're doing is we're going to provide you today CDs of the documentation leading up to this case. Where we are presently. This case is not about double dipping, because the National Guard across this United States in 54 states and territories is structured to receive 2 checks a month. Approximately 6,500 people in the state of Texas receive 2 checks for their service in the military. That's the way it's structured. That's the way it is statutorily according to law. Now, there's argument even aspect of that individuals that are working in the community that make up the difference, they will receive a check from their employer and then they receive a check from the government. But this is not about double dipping. This is about an approved leave status. Now, the double dipping in this case, when it started off, the Attorney General, I'm not sure they know what this case is about. First of all, they started out, it was only me. Then it was only me and one other individual. Then after that, they said, no, there's 5. And it was about double dipping. Then they said, no, it's about an approved leave status. this type of situation of the expectation of what we hold for the Attorney General is wrong. It's anti-veteran, and it's despicable. As a result, I'm fighting this. If you know me, I stand. I stand for what's right. I stand, not that I'm always right, but I'm open to question. In this situation, this issue is about emergency leave. Early on, it was called administrative leave. This situation requires, by law, you move from one status to another status. And the two requirements or the two tenets involved in that is being in an approved leave status and have permission, both of which were satisfied on every time that I moved from state status to federal status, each and every time. Now the state thinks that I owe them money. I don't think so. First of all, I've not figured out how they got that number, and they've not answered our request to tell us how they got that number. But secondarily, as those of you folks that know me, I'm a forensic accountant. I went back and looked at my records, and I think the state owes me. So those are the matters that's at hand, but they decided to move ahead and file a lawsuit against me, and you'll see this in the documentation. There was no due process provided to me or my compadres. They initially came out from the Adjutant General's Department and said we didn't owe any money. Then 2 months later, because of political expediency, they said, no, you owe money, and this is the amount you owe. And you need to pay it in 2 weeks. I sent back a rebuttal illustrating the fact that we were never allowed and granted due process, which is required by law in this state. Again, an example of a political smear against the military, where the military is not afforded the same rights as the other citizens that are around here. Then after that, what contention was, they decided to file a lawsuit against me. But typical aspect of it, when you file a lawsuit, you serve the other person and you give notice to them that you're filing a lawsuit against them. They didn't. They filed a lawsuit. They did not serve me. And so it just hung over my head. And I'm probably the only guy in Texas legal history that had to fight 2 years to get sued. Finally, I was able to get sued, and so by getting into court, we leveled the playing field to the point that we were able to have our voice in court. But the Attorney General doesn't want that to happen. They do not want the voice out there. And as you can see, as a stipulation of the documentation as we go through, is that when we asked for people that were involved in the case, they referred us and transitioned us down to clerks, payroll clerks. The timesheets that were submitted, of which I have my original copies, have been altered. They've been changed. And so from the aspect of asking for discovery, which is where we're at right now as part of the counter petition, we're asking for what evidence they have, and they've yet to provide it. 5 years into the situation, you would think that this was such an egregious situation that they would have been Johnny on the spot with the Attorney General and pushed all their full weight of the Attorney General on this case with all the resources available to bring a senior leader to justice. That has not happened. That has not happened. So as a result, on my own money, having to pay, hiring private attorneys, finding people who are paid, have paid attorneys by the government, we've answered the bell with a counter petition, basically in the court saying, we want to go to court, we believe in our cause, show us the evidence that are against us, because I believe firmly that we're going to be victorious. In that packet of CDs that you're going to get, you're going to see not only the documentation from the attorneys, but you're also going to see where there's an email in there from the head of the state resources for the Adjutant General's Department conveying the direction that the governor wanted us to follow. Took a little bit of liberty in showing that to you, but I feel that you folks could have gotten that from State Open Records Act anyway. You'll see on there my rebuttal that was not considered, as well as a mirror image of what Alan Daynard had on being able to show our position in the request for due process. And if you walk along there, you'll see where we're at today, where we have the counter petition. And Justin has those CDs. You'll see him afterwards. Now my opponent is trying to avoid talking about the issues. When I'm out on the street talking with the voters of Smith County, I'm talking about the issues. I'm talking about the situation of a failed administration, of having been in office for over 7 years, of which he needs to be answerable. And I'm not going to go into a lot of that, but I encourage you folks to come out to our first debate tomorrow at Grassroots. At the doors open 11, and at 11:30 the fireworks begin. So I encourage you folks to come out. So there's discussion about our timesheets. Our timesheets were fully disclosed. They were audited both internally and externally by the state auditor. There's a consideration of the fact of if there was some problems with the timesheets, there would have been a matter of further consideration filed, essentially a letter to our supervisors is saying that we were doing something wrong and to correct it immediately. That was not done. In fact, the state auditor in 2007 said that what we were doing was an adequate business practice. Now, mind you, this is a complex situation, and it's a complex human resource issue to understand. And as a result, it was I who helped champion the change in how time is maintained in the Adjutant General's Department in August of '08. And if you notice, from August '08 to 2009 when I left, there was no confusion about the timekeeping. There was no confusion because it was written down, it was taken care of, it was done properly and accurately. And again, above board and full presentation. In closing, before I answer any questions you might have, my life is in public domain. And so therefore I live as if I'm always on the record. My yes is yes and my no is no. Even though that may get me in trouble sometimes, my yes is yes and my no is no. But the bottom line of it is, I would not have been selected to investigate the alleged detainee abuse at Guantanamo and stand up in Congress and testify the true existence of what was going on there in the interrogation processes and those techniques, back briefing the Secretary of Defense and the President of the United States and members of the Democratic Party if there was anything wrong with my character or integrity. In short, I do things because they're right and it's of service. Just as I made a comment yesterday on my campaign contributions. I'm funding most of my campaign myself because I don't think it's right to live off somebody else's dollars, and that's what I will do as the judge for the county here, is I'll be very frugal and show stewardship in spending the taxpayers' money in the most efficient manner as possible. And so at this time, again, I want to thank you for coming out, because I'm sure there's a lot of people that do not want me to talk about this, do not want me to even broach the issue, but it needs to be put on the table, and that's the way I've led my life. So at this time, I open it up for any questions.